Aaron Asen. I'm an attorney with Richard Strusik Immigration Law. Today we're going to be talking about one of the cases from the recent 2023-2024 Supreme Court term that deals with immigration. The case we're talking about is Campos-Chavez versus Garland. Now, in this particular case, as kind of a background to this, the Supreme Court so when you go into removal proceedings, the Department of Homeland Security is supposed to issue you something called a notice to appear, or an NTA. And in that NTA, the Supreme Court has held that to be complete and to be proper, they must include the date, time, and place of your immigration court hearing. Well, sometimes the DHS doesn't know exactly when that hearing is going to be, so they either leave it blank or they put to be determined, or TBD. In the cases with these non-citizens, they each received an NTA that did not have a specific time, a date, time, or place of their immigration hearing. And as a result, they didn't know when to show up. But the immigration court subsequently issued something called a notice of hearing, which did provide the date, time, and place of their immigration hearing. However, none of them appeared for their hearing, and as a result, they were all ordered removed in absentia. Now, the Supreme Court held that although the original NTA did not have the date, time, and place, the fact that they had received a notice of hearing subsequent to that did contain the date, time, and place, meant that they were responsible for appearing at their court appearances at the date, time, and place listed in the notice of hearing. So what does this practically mean? Practically, this means that if you receive an NTA, or a notice to appear from DHS, and you receive any notice from the immigration court after that, telling you the date, time, and place to appear, you need to follow that. Otherwise, the court will order you removed in absentia. And it doesn't matter if you have an asylum application or you are applying for protection under the Convention Against Torture. You may lose all opportunities to apply for those types of relief if you do not appear. If there is a problem with the NTA or a problem with any of the documents you receive from the Department of Homeland Security or the court, you can always challenge those later. But it is extremely important that you show up at your immigration hearings when you receive a notice with the date, time, and place of your appearance. It's also extremely important that you provide your address, that you keep your address updated with DHS and with the court if you've already received notice. To ensure that you get all proper notices about your upcoming hearings. It is extremely difficult to get a motion or to get an order of removal and absentia reversed. There are very limited opportunities to do this, so it's very important that you not receive one of these orders. For more information, please call Richard Strusik, Immigration Law.